Good afternoon. It's a pleasure to be here. I'm Dan Berkovitz, formerly Commissioner at the Commodity Futures Trading Commission. I've also had the privilege of serving as Securities and Exchange Commission.
He did serve at the SEC as General Counsel, in fact,
Right.
and at the U.S. Senate, a few other very important posts. If I were introducing Dan, it would have taken me 5 minutes to tell you all the amazing things he's done, including his current role, but I'll let him touch on those as we come to them. My name is Kristin Johnson. I am a recovering commissioner of the Commodity Futures Trading Commission. John said I didn't have to say former because I left this month. I don't know if there's a rule about that, but I didn't get garden leave, which I've been hoping to have since my early days at Goldman Sachs. So I left the government and have already been on the road running and working. I was at the commission over the course of the Biden administration and for the current administration from the beginning of the year until 2 or 3 weeks ago. So a lot has happened in the last few months. A lot has happened in the last few years in the context of AI. I'll let Dan start with some of the things we've seen at the CFTC.
Thank you, Kristen. And I'm going to build on the remarks of Senator Graham. I already planned to say this, but Senator Graham talked about the importance of history to what we're doing today. And serving in the Senate and commuting up to Capitol Hill every day, I go past the National Archives. And one of the statues in front of the archives is quoted from Shakespeare, The Tempest, "What is past is prologue." And that's absolutely true in financial market regulation. So I'm going to take a very, very short detour back into history of some of the regulation in the financial markets, because I do think it's important to set the stage and for how the markets and how regulators may view AI. I think it's instructive to look at how the markets and regulators have dealt with prior changes in technology. So I'm going to go back approximately 100 years.
This won't take long.
Post-First World War. The original regulation of the derivative markets, the futures markets, was after the First World War. Basically, at that time, Congress said if you trade grain futures contracts, you had them traded on a regulated exchange. Case went up to the Supreme Court. Eventually, the constitutionality of that law was upheld. We got the predecessor to the Commodity Futures Trading Commission. And then about 10 years later, we had the securities laws passed in the Great Depression, the Securities and Exchange Commission. Interestingly enough, as the commodities and securities laws have developed over the years, back after the First World War, after the Great Depression, after the Great Financial Crisis, when we had the Dodd-Frank, if you look at it, really, many of the fundamental laws were passed in the aftermath of a crisis. It's very difficult actually to get prospective legislation, forward-looking ahead, anticipating issues, and the political will to address them. But after a crisis, there's motivation, there's the interest in the political will. And so really many of the way the commodity statutes and the regulations are devised are to prevent the last crisis looking forward. One question is will we have the foresight to address AI and new technology in a proper way, or is there going to be some crisis that's going to precipitate regulation? The other thing is there's the struggle between, as I mentioned, between addressing the past crises and then looking forward. Some of the more forward-looking statutes, if you look at some of the securities laws, for example, that were passed in the 30s, they're very principles-based. Like the securities laws in the 30s set forth a disclosure regime for the securities markets. And on the commodity side, it's really risk management principles and how you trade and what types of disclosure, much less disclosure. Some more degree of prescription, but not a great degree of prescription in the commodities laws, but they set up regulatory agencies like the CFTC and the SEC, given the administrators or the leaders of that agency in discretion with broadly worded statutes. Thou shalt regulate in the public interest. You shall impose reasonable measures to protect the integrity of the markets, things like that. Broad mandates that can be applied, broad principles that can be applied to any technology. So that's the theory that a lot of the regulatory agencies and statutes were set up under. Now that works if you trust the discretion of the regulators and you have the broad mandates. Recently, there's been a lot of criticism of that, and it's coming to play in some of the legal challenges to the extent of the discretion that the agencies have. Major questions, a doctrine recently enunciated by the Supreme Court that said you really can't take old statutes with broad language and interpret them in new ways to new technologies or industries that have a significant national economic impact. There's a movement to restrict the discretion of the regulators. So the question is which direction do we want to go? Do we want to give, do we want to use our current statutes, the broad discretion that they afford to address AI and this new technology, or do we want specific new statutes and new regulations to address this? I'll give one other example, and this is on the crypto, a very active debate on the crypto side that's occurred over recent years, is the basic rule for determining what's a security under securities laws, what's an investment contract, is the Howey test developed in the 1940s. Basically, it's a case involving orange groves. And so people are looking at crypto and saying, well, does it meet this 4-part test that was developed for orange groves? And people say, wait a minute, why are we using a test for orange groves to determine what securities are? Others folks say, well, these are the principles you decide. And the principles should be technology neutral. I think we had another panel talking about technology neutral principles. So these are very active questions that will, I think, determine which way we're going to go with this new technology. I don't know, Kristin, you face the prescriptive versus principles-based regulation as well. What
are my lessons learned?
Right.
Well, I'm going to begin at the beginning a little bit, not as far back as the turn of the century and the Grain Futures Act, but I love those illustrations. In fact, what I do in my free time when I'm not being a commissioner is teach law school classes. And so Dan touched upon a case that I love teaching in securities regulations, which is the Howey case. And part of the reason it's great fun to teach is not just because students have to try to figure out how to put a round peg into a square hole. How does an orange groves contract for a guarantee around agreeing to sell all the oranges that might be harvested on your land? How does that look like a securities contract? Not just that sort of hard question, in my opinion, but the broader set of questions that grow out of understanding how security laws are meant to be interpreted leave me with the impression that the law is a living and breathing thing. And the idea is that we shouldn't need to organize the law around a specific technology, in part because the principles that dictate or govern how we're thinking about regulation should apply no matter what kind of financial product, no matter what kind of technology. And I would go further and say AI poses a real challenge for financial market regulators and financial markets, in part because it's different in many respects. It's infrastructure in the first instance in ways that a financial product or a platform for offering financial products is a little bit different, right? We see AI used in many contexts across financial markets. I guess we could have started with this in part, but you all are already familiar with the idea that AI technologies would be used in trading and data aggregation and surveillance of markets. We would use AI at the Commission for purposes of identifying anomalies in trading that might illustrate or identify instances where someone's trading with additional or early access to information. We could imagine AI is being used by our enforcement division, the SEC's enforcement division, and other regulators to identify manipulation in markets, efforts to manipulate the price at which some product is being offered. And within the individual firms, it's easily being adopted and utilized for purposes of compliance. That's something that was covered earlier today in extensive detail. Financial services firms are finding ways to integrate AI to facilitate their compliance with federal regulation, state regulation, and more broadly. What I would signal about AI that I think is unique is that we're going to have a really important conversation as a community about what we want to regulate and how. And so a first step in that for the CFTC this past year was launching a request for information, just to ask how our market participants are in fact integrating AI in their daily operations, in trading practices, to help the firms and to help us understand sort of where there might be frictions between how things are operating, where AI is being introduced, and how operations might be transpiring in an analog earlier world, right? So we did get survey responses on many of those questions. I also helped the U.S. Department of Treasury organize a similar RFI that produced a very important report that I think is useful, that's worth talking about. And if I could detour for just one more second, I'd say, apart from simple intended uses of AI, which we need more information about to even begin to think about what regulation might look like, if regulation is a good idea at all. One of the biggest challenges for a lot of financial services firms and for regulators is understanding where financial market participants who are regulated are relying on technology platforms generally that are not subject to financial market regulator oversight. So in other words, they're critical third-party service providers for financial services firms. They are not financial services firms. They only provide code and technology. What is our expectation regarding those firms whose businesses are integral to how financial services firms operate? How are we going to deal with very hard questions around disruptions for those third-party service providers in the context of potential knock-on disruption for financial services markets? And I could go on with an example very recent in our markets that illustrates that. I could even give you several crypto platform-related challenges where essentially cybersecurity attacks or cyber attacks or cybersecurity breaches have led to some pretty significant challenges for crypto firms that are not necessarily regulated in the moment by financial services regulators. So I think these are really big and important questions for regulators and for markets.
Yeah, I would just, again, go back to a historical example, much more recent history on what I would call the point of regulation, like who's going to get regulated. And this involved what we called it the CFTC Regulation AT, automated trading, which now looks like child's play compared to what we're dealing with AI. Because automated trading is very deterministic. You write a program that reacts to certain variables in the market. But after an incident known as the flash crash in 2010, that was supposedly the agencies, SEC and CFTC, thought at the time it was caused by one of these automated programs that did a lot of sell orders very quickly. The CFTC decided to do Reg AT, which was to regulate this activity, that if you're going to operate an automated trading program in the market, you should need a license to do so. And it had a threshold for who would need the license, and then what the standards for these programs were. You had to prevent fat fingers. You had to make sure it didn't go too fast with too many things. And it was what I would call a prescriptive regulation. Well, it got a lot of opposition. But the part of the question was who's going to be regulated? Is it going to be the users of the code? What about the writers of the code? What responsibility do the market intermediaries have in allowing their customers to use their code to get to the exchange? And what was the responsibility of the exchanges in allowing the intermediaries to get to them who were relying on the persons who were using the code written by the authors of the code?
Yep.
So you have all these various points of regulation. Eventually, there was a lot of opposition to proposed Reg AT. The CFTC decided not to go the route it was proposed, and it had a very principles-based regulation that basically confirmed the existing scheme, which is the exchanges have to have rules to make sure trading is orderly, and the intermediaries who have direct access to this exchange, they have to comply with those exchange rules. It did not go to the actual code writers or the actual traders. That's a point in commodities law. The intermediaries are regulated in their access to the market, not the direct persons. Of course, you can't manipulate. But so the question on AT, like, who's responsible for this ultimately? And if a person does something, there's a person there, and the law is designed to get to persons. But what about code that is generative, where the code is actually creating something rather than a person creating something? What's the intent? Whose intent matters?
Earlier in the conversation today, and in my final months as a commissioner, I was really beating the drum steadily on the issue of agentic AI and how, in the first instance, for most regulators, our conversations are almost nearly backward looking because of the time it takes for us to even mobilize a discussion around most things. I'll say that and offer one exception for someone in the room. Val is here from the SEC, but more importantly, she serves in an important role for the IOSCO, the International Organization of Securities Commissions, and she has led multiple work streams that have been really forward-looking. So there are regulators in the universe who are in real time trying to understand and engage with technology and engage with markets. Some of us on the domestic front, however, move a little more slowly. Dan might say a few things about the actual timeline. And so often, if it takes us a minute to write a rule, by the time we've written the rule, we're writing a rule about, I don't know, an algorithm that like a 6-year-old could code in their sleep, which is not something that is nearly generative AI. And therefore, probably our rule is not directly effective for something that is more recently created. So that's to say we have to figure out as regulators how to be in the moment and of the moment in terms of our thinking about these questions in order for our engagement to be relevant and to be useful, right? When I think about AI supervising AI, an AI product that is going to supervise examination process, examination as to whether or not a market participant's in compliance with certain regulatory norms, and the market participant has deployed AI to ensure its compliance with those norms. This is really a very forward-looking set of questions that I have to be honest and say, I don't think, and Dan can correct me if I'm wrong, he can talk about his time at the commission, but in my time at the commission, which ended very recently, there are no conversations being had on this set of issues. And by the time we come around to having them again, this won't be the issue anymore at all. It will be something else, to be quite honest. So there's a lag in terms of our capacity to reach some of these questions using traditional channels. So I think there's really a need for us to re-examine those channels. And to that end, another thing that I've really sort of implored my colleagues in government to think about is interagency task forces that might enable us to domestically and potentially internationally come up with uniform guidelines if that's where we land, or regulation if that's how far we go, but that think carefully about creating rules that are consistent across regulators and not in conflict.
Yeah, I would just, my experience was even under the fastest, and I've worked for some aggressive chairs at the agency and with some of them, 18 to 24 months for federal rulemaking. Okay, and where's AI going to, by the time you do a rule now, put out notice and comment on a proposal 6 to 8 months from now, by the time you're analyzing the comments, your technology has changed significantly. When I was at the commission last, this was back in like the 2020 timeframe, people would come in and say, we need rules on crypto. We need rules of the road on crypto. It's got to be more certain. They said, well, what do you want me to write? I mean, what the technology is changing so quickly. Where's this going to evolve? If you put in a rule today, that rule itself will have a significant effect on the way the technology goes. People will draft or develop technology and draft documents and adopt policies, whatever side of the line they want to be on. So you've got to be very careful. I think Superintendent Harris mentioned the same thing in her talk. There's a balance there between providing certainty but not locking in industry too rapidly. One thing I wanted to touch on quickly, and we both experienced this in terms of government resources do this, both in terms of the use of AI and getting the people to the agencies who know how to use AI and who could oversee its use by the agency and the regulatory side.
That's right. I mean, I'd say for sure, as I was leaving the commission, we were looking at a smaller population of employees than we've had in a very long time in the history of the commission. To Dan's point, in 2010, following the financial crisis, when the entire world economy was really in a dismal state, if you will, as a result of events that had transpired in markets, there was a ramp up. And Dan, you were part of that ramp up at the commission to build out the commission and its resources to ensure against the possibility that there will ever be such a crisis again. And it is a beauty and a blessing, but also a curse, because we solved for that crisis, but we almost solved for the crisis current without any thought toward what the future crises could look like. And so the future crises will not be the very issues that you guys dealt with in the wake of the financial crisis and the development of rules around the Dodd-Frank Act. The future crises will be about something else. AI is going to be present in every market, which means to say, as we're struggling with how to come up with regulation around novel financial products, crypto is one, but I'll tell you, prediction markets is another, where we've regularly had predictive analytics in markets, but increasingly the market for the specific underlying asset for those markets has gone from weather futures or grain futures to now sports events and political contests. These are big deal changes in terms of what's being looked at as products and where the markets are going. And in all of this, AI will play a role without any doubt. And so one of the hard questions for the commission is where to enter into that conversation and how to enter into the conversation and be relevant for what comes next for markets and what comes next in the context of regulation.
In closing, we're just about out of time here. I just make a plug for something that's not very politically correct, but in my view, it's only one of the few ways to proceed. I'm all in favor of a revolving door between the government and the industry on this. It's very difficult in a subject like AI or crypto. I've experienced it in crypto, getting people in the private sector to come into a hot area in the private sector to come in to the government at government pay. Okay, early in your career, there are people senior in their career who who are willing to do it because they make like in leadership positions, they can make a significant contribution. But to get young people, the pay differential is huge, and the career path, those are your development years. And if you're in the government track, you're not in the private sector track. I think I've seen in law, the most successful agencies are the one that do have a revolving door. You come in young, to one place, you spend some time in the private sector, you spend time in the government, it's seen as helping, then you go back to the private sector. There's a flow of information back and forth. There's a lot of, some people think that, government is, everybody's feathering their nest, but it's really not the case for people who go into public service, I believe. But I believe you have to make government service attractive to get people in from the private sector. And given where AI and crypto and the pay differential, we need to be able to attract people in government who have a path out of government into the private sector. And so I think a revolving door type thing would be very helpful. Obviously, you have conflict of interest regulations still all apply.
I'm glad you brought the conflict of interest regulation in, Dan, there at the end, because we definitely want to be thoughtful about that.
Right.
But I think there are many ways. I think you're right about absolutely thinking through the fact that we've trained exceptional lawyers in derivatives and securities and banking regulation, largely in federal agencies, and they've gone on to do great things in the private sector. So, it's food for thought for sure. For sure. Thank you guys so very much. I think the next team is up.